Mr. Presiding Officer, the Honorable Cheese Escudero, the Honorable Senate President, Honorable Win Gatchalian, sa atin pong mga kagalang-galang na Senator Judges, mga minamahal na kababayan, sa loob ng bulwagan o sa labas man, mga nakatutok sa telebisyon, sa cellphone o sa radyo, saang sulok man ng mundo kayo naroroon. Maraming Pilipino ang nagtatanong ngayon, bakit mahalaga ang paglilitis na ito? Ano ang kaugnayan nito sa buhay ng ordinaryong Pilipino? Lubos po naming nauunawaan ang mga tanong na yan. Sa katunayan, may isang driver na nagtatanong, paano sasapat ang kita sa pasada upang mapakain niya ang kanyang pamilya? May isang OFW na nagtatanong, hanggang kailan kailangan lumayo upang mapaaral niya ang kanyang mga anak? May isang guro na nagtatanong, paano pagkakasyahin ang kanyang sahod sa dami ng utang na hinuhulugan? May isang manggagawa na nagtatanong, hanggang kailan magtitiis sa pansamantalang trabaho at kakarampot na sweldo? Sa unang tingin, maaring sabihin na malayo sa buhay nila ang paglilitis na ito. Ngunit hindi. Hindi po. Sapagkat ang usapin ngayon ay patungkol sa isang bagay na pag-aari nilang lahat. Ang kanilang pera, ang kanilang tiwala, ang kanilang karapatan na maningil ng pananagutan mula sa mga pinuno na kanilang pinagkatiwalaan. Kapag ang isang empleyado ay nagkamali ng paggamit ng pera ng kumpanya, siya ay pinagpapaliwanag. Kapag ang isang barangay treasurer hindi maipaliwanag ang nawawalang pondo, siya ay iniimbestigahan. Kapag ang isang principal ay naglustay ng pera ng bayan, kahit 5,000 lang yan, siya ay pinaparusahan. Natural lamang na magtanong ang sambayanan, kung ang ordinaryong Pilipino ay pinapanagot, bakit hindi ang pinakamakapangyarihan na opisyal ng pamahalaan? Ito ang dahilan kung bakit mahalaga ang paglilitis na ito. Hindi upang usigin ang isang tao, hindi upang maghiganti sa kalaban, hindi upang manalo sa politika, kundi upang sagutin ang isang tanong na napakahalaga sa kinabukasan ng ating republika. May saysay pa ba ang pananagutan sa ating bansa? Sapagkat ang kasong ito ay higit at lampas sa sino mang opisyal. Higit at lampas sa anumang partido. Higit at lampas sa alinman. Your Honors, the framers of the Constitution understood that there may come a day when extraordinary power would be entrusted to extraordinary office. They also understood that there may come a day when trust would be broken. And that is why they gave the House of Representatives the power to impeach and the Senate the duty to judge. Not to punish political opponents, not to settle political scores, but to protect the republic itself. That is why the Constitution declares public office is a public trust. Ang kapangyarihan ay hindi pag-aari ng sino mang opisyal. Hiram lamang ito sa taong bayan. At ito ang dahilan kung bakit naririto tayo ngayon. Your Honors, the prosecution will present exactly what the Constitution requires. Evidence. Hindi chismis. Hindi haka-haka. Hindi propaganda. At lalong hindi SOCMED narrative. Evidence. Official records. Financial documents. Government reports. Video recording. Statements under oath. Independent findings of institutions created by law. Mga dokumento na hindi bumoboto. Mga records na walang partido. Mga katotohanan na walang kulay pampolitika. Sa unang tingin, maaring magmukhang magkakahiwalay ang 4 articles of impeachment. Confidential fund, unexplained wealth, bribery and corruption, threat against constitutional order. But these are not 4 separate stories. These are 4 chapters of the same story. Story about power exercised without accountability. Story about public trust betrayed. Story about public office that stopped answering to the public. On the first article of impeachment, the evidence will show that more than 612 million pesos in confidential fund entrusted to the Office of the Vice President and the Department of Education were disbursed, transferred, and liquidated under circumstances that cannot withstand scrutiny. 612 million pesos. Hindi ito pera ng gobyerno. Pera ito ng sambayanan. Pera ng manggagawa. Pera ng magsasaka, pera ng OFW, pera ng guro, pera ng bawat Pilipino na nagbabayad ng buwis at nagtitiwala na gagamitin ito ng tama. The evidence will show liquidation reports supported by questionable documents. The evidence will show acknowledgement receipts bearing names government records could not verify. Names that transformed accountability into a mockery. Pananagutan na naging kalokohan. Names that insulted the intelligence of the Filipino people. Mary Grace Piatos, Milky Sikuya, Kokoy Villamin. On the second article of impeachment, the evidence will show financial transactions involving billions of pesos associated with the respondent and her husband. Billions. Hindi milyon, bilyon. At habang milyon-milyong Pilipino ang nagtratrabaho at nag-iipon buong buhay upang magkaroon ng sariling bahay, makapagpaaral ng mga anak, magkaroon ng kaunting seguridad para sa pamilya. Aba, bilyon-bilyong piso ang dumaan sa mga bank accounts na hindi maipaliwanag ng maayos. This article is not about wealth. This is about accountability. This is about explanation. If wealth was lawfully acquired, where is the lawful explanation? If transactions were proper, where is the complete accounting? If numbers truly add up, then why do they refuse to reconcile? On the third article of impeachment, the evidence will show bribery, graft and corruption through the distribution of cash payments and monetary gifts to officials under the supervision of the respondent. This article is not simply about envelopes. This is about institution. This is about whether loyalty was purchased rather than earned. Government cannot function if loyalty is purchased instead of earned. Kapag nabibili ang katapatan, nawawala ang integridad. At kapag nabibili ang opisyal, nabubudol ang bayan. Perhaps the greatest tragedy is where the conduct allegedly occurred. In the Department of Education. Tama po sa DepEd. The institution entrusted with teaching future generations honesty, responsibility, integrity. On the fourth article of impeachment, the evidence will show culpable violation of the Constitution, high crime, betrayal of public trust through conduct that threatens constitutional order. Among all allegations before this court, none strikes more directly at the heart of constitutional order than this one. Ito na po ang pinakamatindi. And unlike in many cases, which depends upon competing accounts, this evidence comes substantially from the respondents' own recorded public statements. The court will see them. The court will hear them. The court will judge them. Public officials may disagree. We may criticize one another. They may compete fiercely for power. That is democracy. But democracy ends when violence begins. Sa kasaysayan ng ating republika, walang vice presidente na may kaibigan na hitman. Ngayon lang. Walang vice presidente na nagpapapatay ng Pangulo. Ngayon lang. Walang vice presidente na handang magpapatay para lamang makaupo sa pwesto. Ngayon lang. The Constitution provides many means on how to resolve political conflict. Election, legislation, public debate, judicial review, and even impeachment. But it does not permit threats. It does not permit violence. It does not permit people entrusted with power to place themselves above constitutional restraints. Your Honors, at the center of this case lies a simple question, perhaps the most important to any republic. When the people entrust power to a public official, does the public official remain accountable to the people, or do the people become accountable to the public official? The Constitution's answer is very clear. Power belongs to the people. Public office is merely borrowed. And every borrowed power carries with it the obligation to account for its use. If a barangay treasurer must account for public fund, then so must the vice president. If an ordinary public servant can be investigated, then so can the highest officials of the government. If ordinary citizen is expected to obey the rules, then surely those who govern them must obey them first. Otherwise, what lessons do we teach our children? That there is law for the powerful and another for everyone else? That accountability exists only for the weak? That public office grants immunity against accountability? Your Honors, this is not the republic envisioned by the Constitution. This is not the republic deserved by the Filipino people. Therefore, the prosecution asks only this: look at the evidence. Listen to the witnesses. Examine the records. Follow the evidence wherever it leads. Judge this case not by politics, not by popularity, not by fear, not by loyalty. Judge this case by the Constitution. Judge this case by the evidence. Years from now, future generations will not remember today's political alliances. They will not remember today's headlines. They will not remember today's slogans. What they will remember is when accountability was tested, the institutions of the Republic stood firm. They will remember only one thing: what this court did when the Constitution called. Future generations will not ask how powerful the respondent was. They will not ask how loud the political debate became. But they will ask one thing: when the Constitution called, did the Republic answer? Your Honors, this is that moment. This is the moment the Constitution anticipated. This is the moment when accountability must mean exactly what it says. This is the moment when public office must truly remain a public trust. This is the moment when the Republic must demonstrate that laws are applied equally to the powerful and the powerless alike. At matapos marinig ang mga saksi, matapos masuri ang mga dokumento, matapos matimbang lahat ng ebidensya, ang prosekusyon ay naniniwala at naninindigan. Isa lamang ang maliwanag na konklusyon: ang tiwalang ipinagkaloob ay nilabag. Ang kapangyarihang ipinahiram ay inabuso. At ang konstitusyon mismo ang humihingi ng pananagutan. Amid the clarity of the mandate of the Constitution, political noise continues. Political squabbles continues. Political division continues. Please, let me conclude. Salus populi est suprema lex. The welfare of the people is the supreme law. Thank you, Your Honor.
It has 15 minutes, and we will give you the same latitude we gave counsel for the prosecution for an additional 3 minutes, should you so need it. You may proceed, ma'am.
Thank you, Your Honor. Your Honors, fellow Filipinos, good afternoon. As we begin today the impeachment trial of the Vice President, and in the days ahead, this court will undertake its constitutional task of receiving and weighing the parties' evidence, and ultimately to decide whether these pieces of evidence justify either a judgment of conviction or acquittal, guided only by its members' conscience and their solemn oath to do impartial justice. The present undertaking of this court, therefore, not only carries the weight of the Constitution, but also the imprint of our nation's history, because the Filipino people have shown that they never forget. We, as a nation, never forget. But why is the act of remembering important? What does it matter to our history and to ordinary Filipinos? Because in this trial, the prosecution proposes that we unseat the Vice President elected to office by more than 32 million Filipino people, more than the number of votes cast for the sitting President, and much greater than any of the votes secured by each of the members of the House of Representatives who now are here to prosecute her and seek to undo this people's choice. Sa makatwid, ang malinaw na layunin sa likod ng mga paratang na ito ay ang pagpapatalsik sa isang vice-presidenteng inihalal ng mahigit 32 milyong Pilipino at bunga ng kanilang malayang pagpapasya. Whatever one's political persuasion is, The reality is that the prosecution now comes before this court to remove a vice president chosen by an overwhelming number of the electorate. You all have heard the prosecution say repeatedly that this is because they seek accountability, that the people have a right to hold their leaders accountable. This is not a matter of debate. Indeed, the people have a right to demand accountability from their leaders. What we have yet to hear from the prosecution, however, is this. When the Constitution declared under Section 1, Article 11, that public office is a public trust and that public officers and employees must at all times be accountable to the people, serve them with utmost responsibility, integrity, loyalty, and efficiency, act with patriotism and justice, and lead modest lives, the Constitution does not only speak to the Vice President. It also demands the same standards from the prosecutors. Being public officers themselves, the public prosecutors and the members of the House of Representatives are also held to the same constitutional standard. And so we must remember what history tells us. This is not the first time that members of the House of Representatives have attempted to remove the Vice President, and in a manner not compliant with the Constitution. In a July 2025 decision, the Supreme Court unanimously declared in Duterte versus House of Representatives, GR numbers 278353 and 278359, that the impeachment proceedings in the House of Representatives were tainted with grave abuse of discretion, rendering the articles of impeachment that the House transmitted last year to the Senate as void ab initio. Early this year, the Supreme Court unanimously denied with finality the House of Representatives' motion for reconsideration of that decision, with a reminder that while impeachment is a powerful democratic process to call out corruption and grave abuse, impeachment can be abused, and that impeachment should never be abused to maintain the hegemonic dominance of greed by shaming those who occupy high government positions into preventing them from doing what they were sworn to do. But perhaps the most enduring reminder of the Supreme Court that we must not forget in the entire course of this trial is that, in the words of the court, the rule of law that does justice is our lodestar, and that justice includes accountability. Justice includes fairness. Without fairness, there is abuse. This fairness is what our democracy is all about. It is in light of these reminders that we draw attention to certain fundamental legal principles that we think we must not forget throughout this trial. Mga batayang prinsipyo na dapat nating tandaan sa buong panahon ng paglilitis na ito, anuman ang ating kulay o politika. If we are to be true and honest to our proclaimed values, such as the pursuit of accountability, justice, and integrity in our system of government, then we must remain possessed of an unyielding resolve to ensure that the trial and judgment in this case are done in accordance with the command of the Constitution, the majesty of the law, and the discipline required by the rules. Otherwise, those who stand in sanctimonious judgment of the Vice President will send a clear message that the law can be bent when it suits the convenience of the powerful, and that justice can be sacrificed at the altar of partisan interests. Mahalagang tandaan ang mahigpit na paalala ng ating Korte Suprema. Impeachment is not a purely political proceeding. It is primarily a legal, political, and constitutional mechanism. Ibig sabihin, kailangang naayon sa batas at konstitusyon ang anumang proseso nito. According to the Constitution, it is the Senate that shall have the sole power to try and decide all cases of impeachment. This power is not shared. The Constitution gives no other body, department, tribunal, agency, or a mere committee of any of these institutions the power to try an impeachment case. The House merely initiates, the Senate tries. Yet, we have seen the Committee on Justice conduct what its chairperson, the lead prosecutor in this case, described as a mini trial, which, as we all had witnessed, became a vast fishing expedition of alleged evidence that were not even part of the impeachment complaints under its consideration and which the respondent accused was made to answer. In that mini trial, we saw how the purported pieces of evidence were curated to construct a narrative against the Vice President even before this case reaches trial. The articles of impeachment presented before this court as an exercise of the House's power to initiate impeachment cases are therefore, in sober truth, the product of an impermissible intrusion of clear constitutional boundaries. Over the course of the impeachment trial, the prosecution will attempt to convince this court and the court of public opinion that the allegations in the articles of impeachment are supported by materials they obtained during their mini trial and that evidence exists to sustain a judgment of conviction. They will claim that the notices of suspension and disallowance issued by the COA and the COA decision denying the Vice President's appeal of that disallowance support their accusations, with the release of that decision by the COA conveniently timed and coinciding with the committee hearings. They will claim that the certifications of the PSA confirm their allegation that recipients of the confidential funds do not exist, even though they listed one Mary Grace Piatos in their pre-trial brief as among their witnesses, or that the liquidation of the confidential funds in a span of 11 days was allegedly swift as to invite suspicion. The prosecution will assert that the supposed NBI findings of similar signatures across a number of acknowledgement receipts submitted to the COA are supportive of their conclusion that the disbursements of the confidential funds were irregular. What the prosecution avoided informing the public so far are these: that it was the then Secretary of the Department of Budget and Management, Amena Pangandaman, who issued a memorandum for the President through Executive Secretary Lucas Bersamin on October 18, 2022, recommending the approval of the Office of the Vice President's request for confidential funds. That the Office of the President did in fact approve that recommendation of the DBM through a memorandum from the Executive Secretary dated November 28, 2022 and signed by the former Executive Secretary Lucas Bersamin by order of the President. That on December 13, 2022, the DBM issued a special allotment order number SARO-BMB-C-22-001-2004 signed by former Secretary Amena Pangandaman to cover the request of financial assistance, subsidy, and confidential funds of the OVP that, notwithstanding the impending end of the fiscal year, the confidential funds were nonetheless released to the OVP on December 20, 2022 under this documented approval process. That the COA decision is far from being final, that there is a pending motion for reconsideration of that decision that, assuming arguendo, the COA denies that MR today, or while this trial is ongoing, as could plausibly happen under the circumstances, the respondent accused still has legal remedies available under the law and rules and can file a petition to question the validity of any forthcoming resolution of the COA on the MR under Rule 64 via petition for certiorari under Rule 65 of the Rules of Court, and more importantly, that nothing in the notice of disallowance or COA decision states any findings of supposed misuse of confidential funds as confirmed by Attorney Gloria Camora when she was asked on this point during the committee hearing on April 14, 2026. Across all other articles, the prosecution will lay a landscape of what it deems to be their evidence in support of their speculations and conclusions. we are not strangers to all these accusations, precisely because this was not the first time these narratives were foisted into the minds of the general public. We have heard the same tales and stories of these accusations since 2024, when the House conducted its Quadcom hearings and most recently the mini-trial of its Committee on Justice. But what we must not forget amid all these accusations is the fundamental legal principle that the burden of proof never shifts. The burden of proof never shifts. He who accuses must prove his allegations with evidence that meets not only the degree of proof required, but also meets the evidentiary standards of admissibility, credibility, relevance, materiality, and competence. We therefore should not lose sight of the core principle that the burden of proof is on the prosecution, and unless it discharges that burden, the accused need not even offer evidence on her behalf, and she will be entitled to an acquittal. This is the law then. This is the law now. And the underlying principle for this burden of proof is simple. Under our Constitution, every accused is presumed innocent until proven otherwise. An accused has in her favor the presumption of innocence, which the Bill of Rights guarantees. This also brings to fore the reality that, in the words of the Supreme Court in People v. Pagal, the individual citizen is but the speck of particular molecule vis-a-vis the vast and overwhelming powers of government, and his only guarantee against oppression and tyranny are his fundamental liberties under the Bill of Rights, which shield him in times of need. Sa madaling salita, kinikilala ng ating saligang batas na sa bawat paglilitis, ang isang individual ay nahaharap sa malalim at napakalaking makinarya ng buong Estado. At ang tanging sandigan lamang niya laban sa anumang pang-aabuso ng kapangyarihan ay ang kanyang mga batayang karapatan sa ilalim ng ating konstitusyon. Kaya't mahalagang linawin na sa gitna ng pagtatangkang ikondisyon ang kaisipan ng mamamayang Pilipino at sa gitna ng walang humpay na komentaryo sa mga pampublikong espasyo, wala pang maituturing na anumang ebidensya o alegasyon na napapatunayan ng prosekusyon sa simpleng dahilan na ang bawat ebidensya ay kailangang dumaan muna sa paglilitis at pagsusuri ng korteng may tanging kapangyarihan sa ilalim ng ating saligang batas. Higit sa lahat, ang anumang paglilitis ay kailangang naayon sa itinatakda ng ating batas at konstitusyon at hindi lamang sa kagustuhan ng iilang may hawak ng kapangyarihan. One might ask, why is it important that we must not forget these basic principles? The ruling of the Supreme Court tells us why. The Bill of Rights applies to the entire impeachment process because inasmuch as our court recognizes that impeachment is a political process, it reminds us that it is not a purely political process but a legal and constitutional mechanism. Thus, if we are to uphold the rule of law, serve justice, and invoke the accountability mechanism, then this court and we as a people must guarantee that all efforts to hold our leaders accountable must be done right. This we must not forget. I thank the court and the public for the privilege of your time. May God bless our country.